Thank you very much for being here on our panel discussing the Patient Protection and Affordable Care Act, which was enacted into law last year. My name is David Stras. I'm a newly appointed justice of the Minnesota Supreme Court and have spent about 4 months in office. Thank you, and it's my great honor to be the moderator for this panel. I think the format, I want to talk about the format. What we're going to do is we're going to spend, because the arguments are on this issue are fairly nuanced and difficult. We've agreed as a panel that first I'm going to introduce the issue, and then we're going to go in order, and everyone's going to speak about between 7 and 10 minutes. And then I'm going to open it up to some audience questions, as well as questions between the panelists, as well as questions that I may ask as well. So I want this to be an interactive program. I want audience participation, so please feel free. I think we have one microphone in the middle. We may have another microphone as well. Maybe it's just the one microphone. But please feel free to go up to the microphone if you have any questions. So briefly, in giving a broad overview of the issue, President Obama signed the Patient Protection and Affordable Care Act into law on March 23, 2010. The act regulates the insurance industry, for example, by forbidding denials of coverage for pre-existing conditions and allowing adult children to stay on the insurance plans of their parents for a lengthier period of time. But the act also requires all Americans to purchase health insurance from private insurers. In that way, what's been called the individual mandate is probably the most controversial part of the new legislation. It's given rise to at least 4 challenges before federal district courts around the country, and I'll talk about that in a second, challenging the constitutionality of the act, primarily on Commerce Clause grounds and also the necessary and proper clause. The 4 lawsuits, there's one currently pending in the United States District Court for the Northern District of Florida, in a suit joined by about 20 states, and that just recently survived a motion to dismiss, so it's moving along before the trial court. There's also a pending case before the United States District Court for the District of Virginia, which is also moving along, and then there have been 2 cases that have been dismissed. One is in the Southern District of California, and that case was dismissed for a lack of standing, and then there's also a case that was before the Eastern District of Michigan that was also dismissed. Our first speaker today, is David Rivkin, who is the lead counsel in the Florida litigation that I just spoke about, which involves 20 states. Mr. Rivkin is in the Washington office of Baker Hostetler. He's co-chairman of the Center for Law and Counterterrorism at the Foundation for Defense of Democracies, a visiting fellow at the Nixon Center, and a contributing editor of the National Review. As relevant here, Mr. Rivkin also has served in a variety of legal positions and policy positions in the Reagan and George H.W. Bush administrations, including stints in the White House Counsel's Office, the Office of the Vice President, and the Departments of Justice and Energy. And without further ado, I will turn it over to Mr. Rivkin.
Thank you, Justice Stras. It's a tough act to follow, both to follow you and certainly following Michael Barone, but I will do my best. Can the federal government tell all Americans you have to eat free servings of fruits and veggies every day? Does that exceed the reach of a Commerce Clause, either working by itself or is augmented by the necessary and proper clause? That, by the way, ladies and gentlemen, was the exact question that Senator Coburn asked one Yelena Kagan at a confirmation hearing. Her response was, and I quote, Well, the Department of Justice, which is now defending Obamacare's individual mandate in courts, including in our case, has a more direct answer. It is, yep, the government can force you to get your fruits and veggies, and that answer is highly dangerous to our constitutional health. The legal challenge to the individual mandate is actually about much more than health care. It is even much more than just federalism and our system of dual sovereignty, as important as it is, which is the very sinew of our constitutional architecture. At the most fundamental level, it's about the vitality of our Constitution. The individual mandate violates the most fundamental level, the constitutional principles of limited powers and dual sovereignty. It violates centuries of established case law, and it is fundamentally different from every statute regulating commerce that Congress has ever enacted from the very first day of a republic, pretty much up until now. Indeed, if DOJ is right, the framing generation's efforts in drafting the Constitution, the Bill of Rights. All of Congress's legislating in the decades and centuries since are at best incoherent and at worst superfluous. In light of all these problems, I'm hopeful, even confident, that an individual mandate would be struck down. Now, in our litigations, DOJ bottom line is that Congress can regulate commerce by forcing people into commerce and then regulating them, actually all in the same step. Doing nothing, ladies and gentlemen, is an economic activity that Congress can reach for a combination of a Commerce Clause and necessary and proper clause. And this argument has at least 5 major constitutional consequences, all of which violate both fundamental principles and settled case law. First, as I already said, it eviscerates dual sovereignty. I'm going to spare you from quoting James Madison to that effect, but we all know that states have residual sovereignty that cannot be infringed by Congress. It's often referred to as a police power. Regulating an activity by forcing people to do things not based upon activities they voluntarily engage in, but compelling them to act is the very essence of police power. Another key attribute of police power is that unlike regulation of individuals based upon their activities, it cannot be avoided. And nothing captures this distinction better than the fact that all one has to do when dealing with federal statutes regulating a particular activity or commodity, be it wheat or weed, and more about it later from my colleague Randy, is not to engage in this activity, not to touch that commodity, and you'll be out of a federal regulatory vortex. By contrast, when the state of Massachusetts requires all adults to obtain smallpox vaccinations, there's no opting out. If you're an adult and you happen to be within the borders of Massachusetts, the mandate grabs you. To justify claiming that police power for the federal government, DOJ, of course, argues that inactivity, specifically a failure to acquire a particular good and service, is within the scope of a Commerce Clause is augmented by the necessary and proper clause, so long as that inactivity can be linked to an economic effect. The problem, of course, of this argument in modern economy, every inactivity in the aggregate has some economic consequences. There's no meaningful limiting principle, and everything can be swept under the Commerce Clause. Now, recognizing this problem, at least tacitly, the government in defending Obamacare is relying more and more on the necessary and proper clause, but they're being a little funky about it. To begin with, the government clearly is creating its own necessity here to justify the application of a clause. But alleged necessity, ladies and gentlemen, is cost shifting, the prospect that some folks would go to emergency rooms, use health care, not pay for it, shifting the cost to others. But why is cost shifting such a huge, palpable problem here? The answer actually is other government regulations that Congress passed as part of Obamacare. That is very different from a necessary and proper clause as applied in Reich, about which, again, more later on in this panel. DOJ certainly misreads Reich in a standing proposition that Congress may do anything, including reaching inactivity, as a part of a larger regulatory scheme. That is, of course, not the rule of Reich. It's also passing strange to me that Constitution would preclude the imposition of certain legal requirements standing alone, while countenancing readily the imposition of the same requirements if they are packaged as a part of a broader scheme. To put it differently, Congress can pretty much take any step at once as long as it's a big step. Under DOJ's logic, as a matter of fact, Congress should pass very capacious statutes with ambitious policy goals, have them badly drafted as far as the exercise of enumerated powers are concerned, have a regulatory gap, and then presto pronto, you have mandates. In fact, the bigger is the gap, the more is your need for general police power. And at the risk of sounding flippant, I shudder to think how many individual mandates it would take to accomplish the intended purposes of something I call the Happiness and Welfare of All Americans Act of 2011. Now, the second the government's argument rips out whole sections and clauses out of a Constitution, I promise not to quote much, but I cannot help myself. Chief Justice Marshall said in Marbury v. Madison that, quote, it cannot be presumed that any clause in the Constitution is intended to be without effect. Yet on DOJ's view, all but the 2 powers in Article 1, Section 8, namely the Commerce Clause and NMP, are perfectly sufficient to get everything done that the government wants done, so there's no need for any of the other clauses. I guess the framers just weren't smart enough to figure this out. And meanwhile, there's a half dozen other constitutional provisions that the court majority identifies in Prince that, quote, presuppose the continued existence of estates and those means that are and instrumentalities which are the creation of a sovereign and reserved rights. All those become pretty much constitutional artifacts too. Second, third, the notion that Congress can force citizens into economic activity turns the Bill of Rights on its head. We all know the Bill of Rights, of course, is a secondary line of defense. It augments the broader structural and more fundamental protections in the original Constitution, which enumeration of powers is the key. And the Bill of Rights, as we all know, does not do a whole lot to constrain government activity to regulate under the Commerce Clause. So let me see. While Congress cannot compel you to profess your love or adoration for fruits and veggies, it can compel you to buy them. And DOJ's unstated thesis, in my view, is that the very smart and astute folks who worked on the Bill of Rights, both originally and throughout the subsequent national life, and used it as a goal of protecting individuals from the way the government exercises, admittedly, those powers they're granted, they really didn't do a good job because they had this huge loophole because it doesn't very much cover that. Fourth, I would say DOJ's view calls into question the competence of every single Congress before this one. Congress has always, ladies and gentlemen, regulated under the Commerce Clause indirectly and partially than using either Commerce Clause or Necessary and Proper Clause. An example, rather than simply mandate that everybody who lives in floodplains purchase insurance, Congress required insurance only as a condition of securing and maintaining a mortgage from a federally regulated financial institution. Ditto with federal minimum wage, child labor laws, securities laws. They're all tied to interstate commerce and activities. None of them feature direct mandates on inactive individuals. It's been so easy, so very simple, so very direct just to mandate those things. Well, obviously, most Congresses were not composed of very intelligent individuals who had no idea that they were doing. Well, perhaps true in some respects, but certainly not across the board. Fifth, if DOJ's arguments about mandates constitutionality is accepted, it's a very important thing because it's about individual liberty. It's not just federalism. The end result would fundamentally rework the relationship between the federal government and the citizens and the nature of citizenship itself. The few enumerated powers in which the government regulates individuals qua individuals, as distinct from regulating the activities in which they engage, all relate to traditional common law-derived duties and attributes of citizenship. Jury duty censors serving in militia and the military during war and invasion. These powers are all narrow and do not morph into general police power. Moreover, federal government's authority relating to jury duty and military service, for example, inherently involves citizen participation in governmental activities, and yet now DOJ cites them as a precedent for requiring people to buy things, to buy stuff. Have one set of private individuals buy stuff from another set of private individuals. This actually, ladies and gentlemen, alters the very nature of citizenship. Until now, citizens had reciprocal duties to the government in the service of protecting their nation and the rights which it affords to all citizens. In DOJ's view now, the citizens have a duty to basically do what the government tells them to do. The bottom line is this, that in defending the individual mandate, DOJ has ended up disparaging the constitutional text, innumerable court precedents, over 200 years of legislative practice in our system of dual sovereignty. That's a lot, I think, for any court to swallow. Now, I think DOJ understands it. It's nervous that the courts would not buy this legal argument, and they really come up with a second line of defense. And that second line of defense is, they think, is a self-limiting principle, built-in limiting principle. This is the argument, and I quote, "The healthcare market is unique." Okay, what is it? It's a plea of a court. It says, give us this case, just the one-off. If you uphold the statute, we'll never come back to you. It would have no consequences. But, ladies and gentlemen, the healthcare market ain't unique, not by a long shot. DOJ says it's unique because everybody participates in the healthcare market. This is nonsense. Every existing market, even for luxuries and certainly for necessities of life, features inevitable participation by a sufficiently large portion of the electorate. If it were not the case, those markets would not exist. DOJ says healthcare is unique because there's cost shifting. Emergency room not paying for it. But hey, there's cost shifting in every insurance market, in every credit market. Think about it. The guy who defaults on his credit card bills. Indeed, cost shifting is ubiquitous throughout all markets where credit is extended to market participants and people do not pay for goods and services at the time they're received. There's really no limiting principle. The federal government can force you to enter any market, and rest assured, ladies and gentlemen, whatever, quote, unique attributes of that market happen to mesmerize Congress now, to act today, future Congresses would find something else that's unique and applicable to those other markets. Hypocrisy, as they say, is a sort of homage that vice pays to virtue. DOJ is hypocritical when it pays lip service to the constitutionalism, limiting principle, enumerated powers, and then fails to articulate anything resembling that. I actually feel sorry for them because the reason they're not doing it is not because they're very smart, but because there ain't any limiting principle. And that is why I believe DOJ would lose in the end. Thank you.
Thank you, David. Our next speaker, who is also going to be arguing for the unconstitutionality of Obamacare, is Professor Randy Barnett, who is the Carmack Waterhouse Professor of Legal Theory at Georgetown University Law Center, where he teaches constitutional law and contracts. Professor Barnett has written more than 90 articles and reviews, as well as 9 books. As relevant here, Professor Barnett argued the important medical marijuana case of Gonzalez versus Raich before the United States Supreme Court. So, Professor Barnett.
Thanks, Judge. And it's a great pleasure to be here to discuss this great issue. I'm going to take a slightly different tact than David did and my co-panelist. I don't view this exactly as a debate. And it's not structured as a debate. For one thing, we don't get rebuttal. It's really much more like most Federalist Society programs. It's an educational program, and my goal here is to sort of bring you up to speed, I think, on what the law is that governs this case. This is not going to be an originalist talk of mine, unlike the last talk I gave, in which I'm arguing for the original meaning of the Constitution. If it were an originalist talk, we wouldn't be here today, because if the original meaning of the Constitution were respected, it'd be inconceivable that the federal government would have a power over the insurance market in general, because insurance was not considered a commerce among the several states. In fact, it wasn't until 1944 that the court thought that Congress had the power over the insurance market. It certainly wouldn't have been conceivable that Congress could have mandated that people enter into economic activities with private companies. So the originalism is really off the table, and the litigation doesn't make any appeal to originalism at all. It's relying solely on existing doctrine, an existing post-New Deal doctrine. And that's the reason why it is significant that it's now widely recognized. In fact, it's been recognized by all 3 judges who have ruled in any way on the case, including Judge Stee, who dismissed the case in Michigan, that the individual mandate is an unprecedented act of federal power over individual freedom. And by unprecedented, I simply mean it's never been done before. And had it ever been done before, in other words, had Congress ever exercised its Commerce Clause power to make every citizen engage in economic activity, all of you would be aware of that, because you all would know about the mandates that you have to conform your conduct to upon payment of a penalty, upon pain of penalty payable to the IRS. It hasn't ever been done before. The reason it was done this time, of course, was to avoid the exercise of the tax power, because the tax power carries with it certain political consequences, and the Democrats in Congress did not want to incur those political consequences, and neither did the president. And so rather than exercise their tax power, they decided to try to exercise their regulatory power under the Commerce Clause and Necessary and Proper Clause, and that's where they got themselves into trouble. Because it turns out that the Commerce Clause and Necessary and Proper Clause have never been used in this way before, and so that makes this, in some respects, a case of first impression, and then the question is, how will courts resolve this case? Well, the standard way, I think the initial way that most lawyers, most trained lawyers, in fact, I would say most law professors, you just heard this from Michael Gerhardt in the previous panel, would approach this issue is to say, hey, look, this is economic, what the Congress is doing is economic, and we all know that, at least since the New Deal, Congress essentially has a power to regulate the national economy. This being part of that exercise of its power, it's clearly constitutional. We all know that. But it may be something that we all know, and it certainly may be something the constitutional law professors have taught for a very long time. But if you actually go and read the cases, starting in the New Deal, which are supposed to represent this principle, you will find that there is no Supreme Court decision that has ever upheld the power of Congress to regulate all economic activity in the United States, period. Much less given Congress the power to mandate economic activity from people who are not engaging in it at the moment. So there is no such case. There is no such doctrine. Well, what doctrine does exist? Well, it may be a little bit surprising to you to find out that that Congress's Commerce Clause power under existing doctrine is relatively confined. In fact, it's confined to regulating commerce that takes place between one state or another, commerce that crosses state lines. Now, you may say, well, wait a second. I know that it's not limited to that because I had constitutional law and I read NLRB versus Jones and Laughlin Steel and I read Darby and I read Wickard, and I know that Congress has more power than that. Well, if you actually go back and read, for example, NLRB versus Jones and Laughlin Steel, and you read it carefully, you will see that that statute in that case, which was involving the minimum wage, had a number of provisions. One of the provisions barred the interstate transportation or trade in goods that were a product of goods that were made by labor who were paid below the minimum wage. And in upholding that part of the act, the court relied on the Commerce Clause power. Because if you remember Champion versus Ames, it basically said that Congress has this power over commerce that goes from one state to another, so this is a garden variety exercise of its interstate commerce power. But there was another provision of that bill in which the Congress basically ordered manufacturers, in this case it was Jones and Laughlin Steel, to pay their workers above the minimum wage. Now, the court also upheld that view, that regulation. But it did so not under the Commerce Clause power, and one signal, if it's exercising its Commerce Clause power, it's citing Gibbons versus Ogden, which is a Commerce Clause case. But when it upheld that particular provision, which was a wholly intrastate activity, it cited McCulloch versus Maryland. So what does that tell you? By citing McCulloch versus Maryland, what the court is signaling is this is not a pure exercise of the Commerce Clause power. This is, in fact, an exercise of the power under the Necessary and Proper Clause, which you've already heard something about. And pretty much all of the regulation that Congress has done with respect to intrastate activity has been done under that power, under the Necessary and Proper Clause power, in conjunction with its Commerce Clause power. But it has not been a pure exercise of its Commerce Clause power. And that's what you all learned in law school. You all learned the Necessary and Proper Clause and how wide-ranging that is. And the way the Necessary and Proper Clause is understood as being virtually unlimited and subject to no judicially limited doctrine. Once you're, in fact, as a litigator, once you're arguing the Necessary and Proper Clause, you pretty much figure that you've lost the case because the courts are always going to uphold exercises of Congress as necessary, and it's not something that they're going to get into ever since McCulloch versus Maryland said that Congress can do whatever is convenient, or at least that's how that case has been interpreted, not exactly accurately, but that's the way the case is taken to, well, that's what the case is taken to mean. So, why do I say that this is a Necessary and Proper Clause case, even though, generally speaking, courts have upheld the exercise of the Necessary and Proper Clause? Because, as it turns out, if you understand the substantial effects doctrine, as a Necessary and Proper Clause case, you realize that there is a limiting doctrine on the Necessary and Proper Clause. In fact, there's a limiting doctrine on necessary in the Necessary and Proper Clause, and that is the line that the Supreme Court drew in the case of Lopez versus United States, and then reaffirmed in the case of Morrison versus United States, and that is the line between economic and non-economic activity. What the court decided in the 1990s was that the substantial effects doctrine, which had been adopted by the court during the New Deal, had a limit. And that meant the word necessary in the Necessary and Proper Clause had a doctrinal limit. And that limit was that Congress could not reach, under this theory, wholly intrastate activity that was non-economic in nature. Now, why draw the line at non-economic as opposed to economic? That goes back to what the meaning of the word necessary is about, and a debate that took place between Alexander Hamilton and James Madison about the scope of that clause with respect to the First National Bank. I'm not going to go into the details of that debate, but even Hamilton, who was the big government man of his time, basically argued that there was a limit with respect to necessary and proper, and what made something unnecessary and sufficiently beyond the Congress's power to enact is if it was remote. If it was a remote exercise of power, remote from the enumerated power. Now, we heard earlier this morning from Judge Wilkerson that you need judicially manageable criteria by which judges are going to constrain Congress's power, and I agree with that. I agreed with it earlier. I still agree with that. So, it is not judicially manageable for the courts to assess the degree of remoteness of any particular exercise of power as an abstract manner. And in fact, that is really what the government is asking the courts to do in this case. They're saying, look, healthcare, it's unique. Examine this market, Judge. If you look at this market, you'll see it's different than any other market there is. So we want you to examine the merits of our argument, the merits of our policy, and on basis of that, you are to make your constitutional judgment. I don't think that's what the courts will do, and I don't think that's what the courts should do. In fact, the economic, non-economic distinction is a way of getting at remote from non-remote exercises of the Necessary and Proper Clause as it's conjoined with the Commerce Clause. The reason being is that when Congress seeks to regulate non-economic activity, Well, let me start the other way. When Congress seeks to regulate wholly interstate economic activity, that is very likely to be closely related and non-remote to its exercise of its interstate commerce power, as a means to exercising its interstate commerce power. However, when Congress goes over that doctrinal line and starts to regulate non-economic intrastate activity, that is likely to be remote from its exercise of its Commerce Clause power under the Necessary and Proper Clause. So there you have a judicially administrable doctrine by which you limit the range of the word necessary in the Necessary and Proper Clause. But now we face something new and unprecedented. And the new and unprecedented thing is when Congress seeks not to regulate any activity at all, but to mandate activity from a position of inactivity, or another way to say it is to regulate inactivity. So the question is there another limiting doctrine that the courts would and should adopt in order to limit the scope of the Necessary and Proper Clause? And the answer is obvious. And that is, they should draw a line. Just as they drew a line in the past between economic and non-economic activity, they should, and I believe will now, draw a line between activity and inactivity, and do so for the very same reason. Because they don't want to get into the facts about particular laws and decide whether it is more or less necessary, which is what the government is urging it to do in this case. They want to draw a bright line that would separate the limited and enumerated powers of the federal government that were reaffirmed by Chief Justice Rehnquist in the Lopez case, and draw a line that is judicially administrable. This is that line. When Congress seeks to regulate wholly intrastate activity, that is economic in nature, that is likely to not be remote, that is likely to be close or incidental to the exercise of its Commerce Clause power. Similarly, with the new theory that the government is arguing for, which is based on dicta in Lopez, dicta in Raich, and also Justice Scalia's concurring opinion in Raich, that Congress can reach even wholly intrastate non-economic activity if doing so is essential to a broader regulatory scheme. That's the new theory, and I believe it's predictable that the courts will adopt that theory. The economic and non-economic distinction line provides the limiting doctrine of that doctrine as well, of that theory as well. Okay, Congress can reach wholly intrastate activity that's non-economic in nature when doing so is essential to a broader regulatory scheme, but it cannot reach wholly intrastate inactivity. That is a line beyond which it will not go. So let me just close. I see I've got to close now. Let me just close by saying this. When you get up in oral argument and you argue a case like this, the most telling arguments against you are the slippery slope arguments. If we rule for you, counsel, we're going to have to rule, what other laws are we going to have to undo? What other laws are we going to have to strike down? In fact, those were some of the toughest questions I had the day that I argued Gonzalez versus Raich in the Supreme Court of the United States. But whenever the lawyer gets up to argue this case, they're going to have to, and I argue this principle, this limiting principle, the inactivity-activity line with respect to Congress's Commerce Clause power, they're going to have a very easy time of it. Because as it turns out, there would only be one law that would have to be struck down as a result of adopting this particular doctrine. It is the individual mandate. And you know why? Because it's unprecedented, because it's never been done in the history of this country, and no other law would be affected by adopting this limiting principle, making it that much easier for a court to adopt. Thanks.
Thank you, Randy. Our next speaker, now we're going to turn to two folks who want to talk about the constitutionality or argue for the constitutionality of Obamacare. Our first speaker is really needs no introduction. It's Charles Freed. Charles Freed is a full-time faculty member at the Harvard Law School, has previously been an Associate Justice of the Supreme Judicial Court of Massachusetts, and specializes in his capacity as a law professor in courses on appellate advocacy, commercial law, constitutional law, contracts, criminal law, federal courts, labor law, torts, legal philosophy, and medical ethics. So he's got a lot of specialties. So without further ado, I will turn it over to Professor Freed.
Thanks very much. You know, an introduction is not an affidavit, so that's all right. I'd like to start with something my good friend Randy spoke about, Morrison and Lopez. I'm very proud of Morrison because I sat next to the winning arguer in Morrison when it was argued in the Supreme Court and helped brief that case. And the thing about Morrison and Lopez was that the court said, well, beating up your girlfriend is not commerce. Bringing a gun within a school, that's not commerce. And I thought that was a very reasonable thing to say. However, the idea that insurance is not commerce is an idea that since 1944, I think had best not be produced before any court. Because in 1944, the court quite explicitly said, yes, insurance is commerce. And indeed, in the 60s, I think it was, in the Perez case, the Supreme Court said that local loan sharking, pay back at 150% or break your knees, that is commerce. Well, if those are commerce, insurance is commerce, and loan sharking is commerce, then I think the 18% of our national economy, which the insurance industry partially pays for, surely is commerce. So it's commerce. I think there's no serious question that health insurance is commerce. Well, yes, but here, and this we've heard this now twice, and we hear it all the time. Yes, but Congress under the Commerce Clause has the power to regulate economic activity, not inactivity. Well, here is what Chief Justice Marshall said in Gibbons v. Ogden. The power in the Commerce Clause, it is the power to regulate, that is, to prescribe the rule by which commerce is to be governed. It doesn't say to prescribe the rule by which the persons engaging in commerce are to be governed. It says to prescribe the rule by which the commerce is governed. The commerce here is health insurance. And what the individual mandate does, it prescribes, along with many, many other rules, some of which, by the way, I think are of doubtful constitutionality, such as those that require states to unfunded mandates for Medicare and Medicaid. But on this, it is prescribing a rule for the activity, for the economic activity, which is health insurance. And that is the rule, that is what Marshall told us at the beginning of the 19th century, and that, of course, is the basis for saying that the individual mandate is part of the rules for the activity of health insurance which the Congress is prescribing. It is prescribing the rule by which commerce, to wit, health insurance, is to be governed. Now, it is ironic that the reason that we have the individual mandate is because, for good and sufficient reason, Congress and the public were very wary of having a government option. Because if we'd had the government option, which thank goodness we do not have, because if we'd had the government option, pretty soon the government would be running all of our health care, which, by the way, Randy, would be regrettable but completely constitutional. As Holmes would have said in Lochner, the reason we have the individual mandate is so that health care can remain in the private sector insurance. And you couldn't have had no pre-existing illness, you could not have the large coverage which this is intended to procure without the individual mandate, for reasons that are so obvious I won't rehearse them. And the individual mandate that therefore came in because of a reluctance to have the only other way to procure those benefits, which would have been the government option. So it's ironic that the attack is on the one thing which actually made the government mandate unnecessary. Now, once we've said that what the individual mandate is, it's part of a system of rules that regulate commerce. What about this? Well, yes, but this is regulating inactivity. Well, if you want to put it that way, fine. My question is to Randy, so what? So what? Where in the Constitution does it say that Congress only has the power to regulate activity and not to regulate inactivity? What Congress has the power to do is to regulate commerce, which is what it is doing. What's left of this activity-inactivity argument is not a Commerce Clause argument at all. It is a liberty argument. And liberty arguments cause my heart to beat faster. I love them. But that is what it is. And if this is a liberty argument, then, of course, it has nothing to do with the power of Congress, excuse me, it has something to do with the power of any government. And on that argument, not only is Obamacare unconstitutional, but so is Romneycare in Massachusetts. And that has that has all the features of an argument that proves too much. Now, how about this individual liberty argument about the few $100 that people who could afford it will have to pay if they don't sign up with an insurance company? Well, I'm glad to see somebody mentioned the 1907 Massachusetts against Jacobson case, because that was the case in which people who didn't want a smallpox vaccination had to have one anyway, not for paternalistic reasons, but because they would infect all the rest of us. Similarly, the reason for the individual mandate is not for paternalistic reasons, because I suppose if you could get somebody convincingly to agree never to use medical care, though he is dying on the streets, which of course is nonsense, then it wouldn't be paternalistic, but this is because of what it does to everybody else. That is the explanation. Thank you.
Thank you very much, Professor Freed. Our last speaker is Richard Cordray, who was elected as Ohio Attorney General in November of 2008. He has previously served, and this is a long list, a lot of public service: Ohio Treasurer, Franklin County Treasurer, State Representative, and as Ohio's first Solicitor General. As Solicitor General, Mr. Cordray represented the state in the most difficult and important cases before the U.S. and Ohio Supreme Courts. Mr. Cordray has argued 7 cases before the U.S. Supreme Court and has taught constitutional law for 13 years at Ohio State University. Mr. Cordray.
Thank you, David. I'm particularly appreciative of following Charles Freed to the lectern, because I had my very first legal experience under him when he was Solicitor General of the United States, and I was a law clerk just out of law school. So I'm pleased to see that 25 years later we still agree. So thank you. As to originalism, which was mentioned and then set aside, it is true that the U.S. Supreme Court did not say until well into the 20th century that the insurance market is an interstate market, and therefore I suppose on those grounds you could say that originalism would not countenance this regulation. Of course, the founders knew nothing about colonoscopies and CAT scans and heart bypass surgery, so perhaps much of modern healthcare would be unrecognizable to them. And just as there was no insurance industry for them to contemplate at the time of the founding, there was no railroad industry or automobile industry, and none of those, I suppose, could be regulated. So we'll set originalism aside, as Professor Barnett set it aside. In terms of the arguments here, one thing that's notable is that so far at least, one issue that is put forward in these lawsuits that is entirely dropped out of the discussion is the 10th Amendment commandeering or coercion argument. Still alive in some of the lawsuits, but to my mind, a very weak vintage. The argument is that because the Affordable Care Act changes the Medicaid program in significant respects, that it somehow forces the states and commandeers them into action. That is not, in fact, true, nor is it a constitutionally justifiable argument. The Medicaid program is and remains entirely voluntary for the states. The fact that all 50 states, and it wasn't 50 for a long time, but is now, that all 50 states choose to engage in the Medicaid program and to work cooperatively with the federal government in that program means that they are making a choice, and they are deciding that it is worth it to their citizens to be participating in the Medicaid program, regardless of the different conditions there. And the fact that all 50 states are making the same choice does not show that any of them is being commandeered in the choice that they're making or coerced. There are significant changes in the Medicaid program under the Affordable Care Act. Many of them are financed pretty generously by the federal government. Not all of them are financed entirely by the federal government. The states will continue to have their choices to make there, and there isn't really any strong or justifiable 10th Amendment basis for striking down this law. So we're back to the Commerce Clause argument, and much of what I would say echoes what Charles has said. There's no question that health insurance and health care generally are economic activities. Not only economic activities, but enormous economic activities as part of the economic activity that's engaged in our nation as a whole. There's no question that this is an interstate market now, that it cannot be sufficiently regulated on a state-by-state basis. Congress has made those judgments. Congress has determined that regulation at the federal level is necessary to solve a national problem, and they have legislated. There's a lot of political heartburn about what Congress did and how it did it. Those issues are more properly hashed out in the political sphere. As they were, as I saw it, and I was on the short end of the stick 2 weeks ago, they were hashed out pretty successfully by a lot of candidates in the elections 2 weeks ago. And that will create a new Congress, and they will have their chance to have their own say on these issues. That, to me, is the proper place for these arguments to be debated and for this issue to be resolved. But since it has been taken to the courts, the question that remains is whether it violates the restrictions on Congress's constitutional powers to legislate under the Commerce Clause about health care. Nobody really questions that there can be health care reform law legislated by Congress. That is not a serious argument. The issue instead is a subsidiary one, whether the individual mandate somehow is unconstitutional as some reading of the Commerce Clause power, even though health care itself could be addressed by the Congress. That's the issue here. And let's be clear on what's being argued here. Essentially, what's being said is that when you have an economic issue, a national economic issue, a significant economic issue that Congress decides it's important to legislate upon, that if in fact embedded in that economic issue there is a free rider problem, Congress will not have the authority to address the free rider problem by mandating anything by the free riders. We have a very significant free rider problem in the healthcare field. It's 40 million plus of free riders across this country. Congress recognized that if it was going to effectively address the healthcare issue and the health insurance issue, it would have to address that free rider problem. If you say that Congress cannot do that here, you're saying Congress can never do that. So whenever you have an economic issue where part of the problem to resolve it is to address a free rider issue, Congress will not have the power to address that issue by mandating anything of the citizens, even though there's no real argument, nobody's making any argument in any of these cases, no serious argument at least, that those mandates at all violate any provision of individual liberties under the Constitution's Bill of Rights. So you're poking a huge hole in the Commerce Clause power and the economic regulatory power that the framers of this Constitution granted to the United States Congress. You're saying they cannot address that aspect of an economic issue. The states presumably can, although I agree with Charles, it's somewhat fuzzy here in the argument. There's a lot of flourish, but the real question is whether this really is an authority question or if it's a liberty question. If it's a liberty question, it's a little different than what has typically been argued, but that's what's being smuggled in here, and it's hard to find that in some provision of the Constitution. So presumably the states could continue. Massachusetts can continue. The states can continue what they do with auto insurance, but the federal Congress is disabled from addressing that problem in the same way. I don't think that that's a proper reading of the Constitution. I don't think it's consistent with the precedents. Again, the notion that somehow people have a right to be able to free ride in a market as important and as significant and economically powerful as the healthcare market in this country, people who are going to receive health care from time to time and want to be able to dip in and out of the insurance system as most advantages them at a given point in time, depending on whether they feel healthy, whether they're foreseeing that they'll be healthy next month, next year, or whether they now feel that they are going to need the kind of coverage and care that the health insurance system will provide. That may be a liberty that people want to assert. It is not one that they have a constitutional right to assert. It is not one that is protected by the Constitution. And Congress has every ability under the Commerce Clause and under the Necessary and Proper Clause to address this issue as it has done, in my view. I thought it was interesting that David Rivkin characterized the government's argument here as just give us this one case and we won't come back and trouble you again. And then by the end of the discussion, Professor Barnett was essentially saying, all you need to do is give us this one case, and we won't come back and trouble you again. That this isn't Reich, this isn't the other cases, this is a unique one-off. In fact, this is part of a long tradition of Commerce Clause cases in which the U.S. Supreme Court has grappled with the issues over many, many years, and they have settled now for the last 3/4 of a century that any economic matter in which the matters being regulated have substantial effects on interstate commerce are within Congress's authority to address. That's nothing more and nothing less than what Congress has done under the Affordable Care Act. It's nothing more and nothing less than what the court ruled in Reich, what it ruled in Wickard versus Philbin, what the lower courts have ruled in many different areas of commercial activity since. And it is, in fact, totally consistent with an understanding of our Constitution that was the framers' understanding, which is there are going to be problems that will be not foreseeable to us, but foreseeable within the principles of this Constitution. And the political branches of our government have to have the authority to be able to address those issues in the public interest as they see it. If they fail to do that in a manner that the public at large thinks is appropriate, the public at large is at liberty to vote them out and is at liberty to replace them with others who will legislate more to their liking. But it is not a constitutional issue to be decided by judges to block the Congress and the political branches from addressing the felt needs of our society within the powers enumerated in the Constitution, including the rather capacious power, let's be frank about it, granted to regulate interstate commerce in Article 1 of the Constitution. Thank you.
to go to the center of the room, and if you have any questions for our panelists, I think I'm going to take the moderator's prerogative and ask each side a question, and I'll start with Rich and Charles. Now, I think that the argument that David and Randy are making is that this particular piece of legislation expands the Commerce Clause in a way we've never seen before. In other words, it's a novel application because of the activity-inactivity distinction. So my question is very basic. If this law is allowed to stand, what about laws ordering people to buy Fruit Loops and eat Fruit Loops? Because certainly that's economic activity. So where is the limit of Congress's power?
Well, so as not to seem to duck, I suppose Congress would have the power to say that people have to pay for Fruit Loops. I think it is a substantial liberty matter to say they don't have to eat them. I couldn't agree with you more. Although in Jacobson, where there was a real imposition, a needle into the body, the Supreme Court was quite clear that they could mandate that. But we have a larger view of liberty interests now, and that liberty interest, I think, would extend to not being required to eat Fruit Loops. I'm with you all the way on that. But you might have to pay for them. Yes, very much like in the cases of those poor people who had to pay for the advertising for beef and for tree fruits, though they didn't want to do it, all under the Commerce Clause. You didn't have to eat the beef, and you didn't have to eat the tree fruits, the stone fruits, but you did have to pay. And that's the same thing here.
I would agree, although I think we rely on the political sphere to weed out a lot of stupid ideas. And for the most part, it does. And when it fails to do so, there are elections that can weed out the people who had the stupid ideas. But let me say, there are lots of ways in which Congress has directed economic activity over the years, most of which are not considered to be constitutionally problematic. Every time Congress or the federal government or the local, state or local governments exercise the power of eminent domain, they are forcing unwilling individuals who prefer to be inactive and to sit quietly with their property to sell their property to the government. Now that's specified by the Constitution, but it is forcing people to engage in economic activity who would prefer simply to be left alone. In the first Congress, there's an example, there are many examples over the years, of free men being required to purchase products as a condition of being an American citizen. Again, that's presumably justified under the military powers that Congress has, but it's not conceptually distinct from having a Commerce Clause power that Congress clearly can exercise to regulate health care generally and health insurance generally, and then saying that a specific subsidiary provision of the law is necessary and proper to carrying it out. So again, I don't think that that Congress is disabled from requiring economic activity from people, and they condition and limit and constrain our economic activity all the time. There's been a question of could people be required to buy an American-made car? Well, Congress certainly legislates that every time that it imposes restrictions on imports that bar certain imports. They're forcing you to buy that product, if you want to buy it at all, from an American producer. So there's much that Congress can do. Ultimately, there are significant limits imposed by the political process itself. That's the proper way for a lot of these things to be hashed out. And the fact that you can come up with counterexamples that seem odd to us doesn't mean that the political process doesn't work. Typically, it does not produce those odd results.
May I just add this? Imagine, which after the Heller decision I can more easily imagine, a congressional statute that required everybody to have a gun in their home or to pay the equivalent. Now, you might have First Amendment free exercise objections, but I don't think you would have a Commerce Clause objection.
I wanted to commend both Richard and Charles for being candid. Usually it takes a number of hours to cut through the chase, but let's be clear that people who are defending this statute have stipulated that as far as the structural limitations on Congress's authority, which, by the way, I'm puzzled by the distinction between authority and liberty, because the structural limitations are there not for purely formalistic reasons. They're first line of defense of protecting individual liberty, and there's enormous difference with respect, General Fried, between what a state can do and what a federal government can do. But you have all conceded that, as a structural matter, the federal government can require people to purchase all manner of goods and services, and that the only check on that is a political check. Well, a couple of points on that. First of all, there's plenty of case law, gentlemen, not just in Lopez and Morrison, but every major Commerce Clause case, including the cases that have brought the Commerce Clause to its modern post-Indio parameters, that emphasize the need to have a judicially administrable limiting doctrine, not political doctrine, not trust us, we're not going to do something stupid like the Fruit Loops. I wonder how you all would have reacted if in the days of George W. Bush administration we had debates about warrantless wiretapping. You know, I would have come out and say, you know what, man, trust us, the Congress would only do, you know, the executive branch, president elected by all the people, would only do when it's really, really necessary. We're facing a mortal threat, but in other circumstances it wouldn't happen. So you know what, it ain't justiciable. This is all justiciable. This is all subject to being enforced by the courts. And as both myself and Randy have explained, the fatal problem with your argument, leaving aside all the semantics about regulating matters and subjects, there's nothing in the Constitution that allows Congress to regulate issues or matters or subjects. Leaving all that aside, the fact that there's no meaningful, judicially enforceable doctrine here dooms what you are defending as inexorably as, unless you think that the Supreme Court is going to overturn all of its jurisprudence that talks in terms of the need for that principle. And again, not to repeat myself, healthcare ain't unique. Every failure to purchase something has impacts. And with all due respect to Richard, I'm tired of hearing about free riding, because there's free riding in every sphere of life. Americans, as I mentioned during the argument, welch in roughly $70 billion worth of credit card bills, and what happens to those bills? They passed around to all of us. And people welch in their mortgages, and people declare bankruptcy in accordance with congressional statute, and billions of dollars get passed to all of us. So there's cost shifting in every sphere of human activity. The only way not to have cost shifting is to say you pay cash on the barrel. So under your logic, to cure cost shifting and the free rider problem, you can have infinite set of mandates. That cannot be. To paraphrase a favorite line from a famous Scalia dissent, this is not the country I will recognize.
Let me ask a question for both David and Randy, which is, you seem to be pushing for a bright line rule on the activity and inactivity distinction. We had bright line rules in the Commerce Clause context. For example, manufacturing is not commerce, according to early Supreme Court precedent. I think that was the E.C. Knight case. Is that consistent? And frankly, there's a basis in Morrison, for example, for the economic, non-economic distinction. You can make that case in the Commerce Clause. But for the activity-inactivity distinction, maybe there's not as much there. So how does your view square with recent cases like United States versus Comstock, Gonzalez versus Raich, and some of the more recent cases of the Supreme Court?
I was going with you, and then you raised those other cases, and it sort of threw me a little bit, because that wasn't what I was thinking about. The activity-inactivity distinction is in the cases themselves, insofar as every case that has employed the substantial effects doctrine to date has referred to the regulation of activity. So it's not something that's being made up. It's not something in the Constitution. I agree with Charles about that. It's something in Supreme Court decisions. I've tried to avoid talking about the Constitution the way the Supreme Court typically avoids talking about the Supreme Court, the Constitution. Just confine myself to the original meaning of what their decisions were, which we hope that they will actually try to follow. And the word that they continue to use is not economic matter, which is General Cordray's term. There is no doctrine. There is no economic matter doctrine, and the term economic matter has just appeared for the first time in a government brief. There's economic activities is what they talk about. So we didn't make this up. We just read the cases and saw that in every case, actually, here's what's happened. What we're doing the same thing that Chief Justice Rehnquist did when he decided Lopez. Prior to Lopez, there was no economic, non-economic distinction expressly in the previous cases. But what Chief Justice Rehnquist did, he says, okay, fine. We start as first principles. Actually, that's exactly how the opinion starts. We start with first principles. This is a government of limited and enumerated powers. It doesn't have a police power. So there must be some limit to this doctrine. Well, what is the limit? He says, okay, we're going to look back at all the cases that had previously been decided under the substantial effects doctrine, and we're going to see that in every one of these cases, they involved economic activity. So we are now going to note, we noticed that fact. We hadn't noticed it before. It wasn't in the cases themselves, but we're now going to notice that fact. And that's going to be the line we're going to draw. Didn't exactly theorize why that they drew the line there, but I think there's a good argument on the basis of remoteness why they should. Here, we're actually doing the exact same thing. We've never come across this problem before. The government has never mandated economic activity before, so we've never had to have a doctrine to explain whether they could or whether they couldn't. So what are we going to do? We're going to look back over the previous set of cases, the very same cases that Chief Justice Rehnquist looked back on, the substantial effects doctrine cases, and we noticed that every one of them involved the regulation of activity and none of them involved the regulation of inactivity. And we say that that's an appropriate line to draw there as well. Why? Well, I gave you one reason, which is the same reason for the economic, non-economic distinction, which is remoteness. But there's another reason as well. If we move from necessary, we can move over to the word proper. So let me ask you this. Prior to the 1970s, or 1980s or 90s, was it proper for Congress to exercise its Commerce Clause power by mandating that local sheriffs run background checks as a means of exercising its Commerce Clause power over the sale of guns in the United States? Well, it was necessary. They thought the Congress deemed in its own judgment, it had a rational basis for thinking it was necessary that local sheriff's offices run these background checks. Well, the court in the case of United States versus Prince held it was unconstitutional. Notwithstanding the fact that it might have been necessary, they held that it was an improper commandeering of local government. And why was it improper? In fact, Justice Scalia said under the Necessary and Proper Clause, this is an improper exercise of power. Why? Because of the sovereignty of the states. It interfered unduly with the sovereignty of the states. It wasn't a liberty argument, because states don't have liberty interests under the Constitution. It was a sovereignty argument under the 10th Amendment and other provisions that Justice Scalia pointed to. In particular, the 10th Amendment says that the delegation of powers by this Constitution that are, to the United States that are not prohibited by the states, not prohibited to the states, are reserved to the states respectively, or to the people. Wait a second. Oh, so this is the sovereignty provision of the Constitution that says in which state sovereignty is located, but it turns out the people are there too. There's popular sovereignty recognized by the 10th Amendment, not simply state sovereignty. So what is a mandate? A mandate is a commandeering of the people. That's what it is. And we call it what it is. And it's an improper commandeering of the people in the very same way that the commandeering of state executive branch officials is an improper commandeering of the people. Now, I want to say, is it ever possible? Is it ever okay for Congress to commandeer the people or to mandate the people? Of course it is. We've seen it. But it's very, very limited circumstances. You can be forced to register for selective service. You can be forced to file a tax return. You could be forced to fill out your census form. You can be forced to do those things. You couldn't, by the way, be forced under federal power to buy weaponry. That was an exercise of the state militia power, not the federal power. But even though the federal militia had a statute organizing the state militia, the militia was a pre-existing creature of the states. So, actually, a pre-existing creature of the people that the states themselves would regulate. So, yes, occasionally Congress has mandated people. But then we have to ask ourselves, on what grounds can they mandate it? What's the justification for it? And when the court had to answer that question in the selective service cases after World War I, they said the reason why the draft did not constitute improper commandeering of the people under the 13th Amendment, which bars involuntary servitude, is precisely because every citizen has it's a fundamental duty of American citizenship to go to the aid of the government that is in turn protecting you. So essentially what the government is claiming here is that it is a fundamental duty of American citizenship to purchase a good in the marketplace when Congress deems it convenient to the regulation of interstate commerce. And if this case is upheld, if this mandate is upheld, that will be the principle that it will establish. That because they can draft you into the military, because they have the power to draft you into the military, they have the power to make you do anything. And that runs against, I think, what makes America America. It's what separates the United States from other countries. It's the limited numbers of the duties of citizens that we have. And I think that if this principle is established in this country, we will not be the same country as we were before it was established.
Let me just let me just add that Randy and I are in strong accord, but to be even additional responsiveness to the questioner, lawyers do not like, typically, litigators don't like to advocate bright line tests, but regulating inactivity is not susceptible to anything but a bright line test, precisely because all inactivity is the same. There's no difference between one inactivity and another inactivity, and all inactivity has economic effects. I would ask my co-panelists to name some form of inactivity that in aggregate does not have economic impacts. And by the way, I also don't understand the almost ritualistic incantation about 1/6 of the economy, because much as Randy and I think that the Commerce Clause and NMP are not as capacious as probably you think, it ain't as narrow as to say that if it's 1/6 of the economy, you can regulate it. But if it's 1/20 of an economy, your regulatory writ is somehow weaker. So the 1/6 is not a meaningful factor. Any inactivity is as much, no different from any other inactivity. In the aggregate, it has some economic impact. So it has to be a bright line test or nothing. And the government has had enormous problems coming up with that, and they're very good lawyers. So I think the thing requires the bright line test.
Do either one of you want to respond? And then I do want to get to the audience questions.
Just a couple of things. First of all, activity, inactivity. Don't lose sight of the fact that what Congress has required here is that you pay money. It has not required, as in Jacobson, for instance, that you allow somebody to stick a needle into you or make you do something. You pay money. And I believe we're all familiar with that on April 15th. Paying money is quite a normal mandate, which we're familiar with. Second, I would like to add on the 10th Amendment cases. The court was very clear saying that Prince and those cases got the Constitution wrong, because if the federal government cannot commandeer the states, if it wants people to do anything, it must commandeer the people directly. It cannot commandeer the states to commandeer the people. That is what the court said. So that's the dual sovereignty argument. You have the federal government commandeering people, the states commandeering people, but not the federal government commandeering the states. That's what those cases said over and over again.
Thank you. Let's go to the audience question. Go ahead.
Richard Cordray said that, this question is directed to you. You said that there were 40 million free riders on the healthcare system, which I guess is the same as a polite term for freeloaders, but it amounts to the same thing. At any rate, how on earth can you claim that this Obamacare will reduce the number of 40 million freeloaders? It's more likely, indelibly, to make it permanent and increase many, many more persons to that list. Add many more persons to that list. How can you say that these 40 million people will no longer be freeloaders?
Well, a couple things. First of all, what you're raising to me is a point of political judgment. as to whether this is the right regulation, the wrong regulation, whether it should be changed in some respect, whether it will succeed in accomplishing its purposes or not. Those are important debates to have, but they're political debates. They're not constitutional debates. Secondly, what I said was that there are 40 million plus free riders on the system, meaning people who are uninsured. That doesn't mean they're all freeloaders. Under the current system, many people don't have insurance because they can't afford it. Part of that, the Act is attempting to address that. There are other people who choose, and these would be the freeloaders, they choose to find it advantageous for the moment to not purchase insurance, to save the money they would otherwise spend, while we know that in the aggregate, out of that group of people, some of them ultimately will have unexpected things happen to them, injuries, illnesses, problems that will lead them into emergency care and other things where the rest of us will pick up the tab. That's what's going on under our current healthcare system. That's part of what's unsatisfactory about it. That's what's led Congress to try to address it and some of the states. So, again, none of that is a constitutional argument, and we could argue in a different vein than what we're doing here, whether the Affordable Care Act, or as you prefer to term it, Obamacare, is going to accomplish the objectives that they've set out to accomplish, or whether it will have to be revised in various respects, or whether some of it will prove unsuccessful. I think with any ambitious legislation like this, it probably will have to be revised in certain respects, and we'll get a clearer picture of those as we go. But none of that renders it unconstitutional.
All right.
Can I just say 10 seconds, and that's not a legal argument, Richard, but with respect, I think any serious observer of this scene understand that the real purpose of a mandate is not to help cure even the free rider problems you discover, but effect a cross-subsidy, primarily from the middle class, because the poor folks would get all the subsidies and could have been given them by the government. To effect the subsidies from cross-subsidization from middle class, the people who don't have a benefit-rich package, to pay more than what they need or going to get. And the reason for it, honestly speaking, is because the people who passed it were too easily to get enough taxes done. And back to my good friend Charles here, yes, there's one constitutional proper way of squeezing money out of people, and that's the tax power, properly used. It ain't to force one set of people to cross-subsidize another. You don't tell people who own restaurants to feed the hungry for free. You tax them, and you come up with food stamps. You don't force owners of apartment buildings to give out free apartments as a percentage of their block of apartments. You raise taxes, and then you give people housing vouchers. That is the only constitutional way. And by the way, tax power has its own limiting principles, requirement of apportionment with regard to direct tax and various other things. So even that is not infinitely capacious. But you certainly don't squeeze the cross-subsidy. That this is all about. Does anybody really disagree with that?
I do disagree with that. I think some of it is about the free rider problem. Some of it may be cross-subsidization. It's not unconstitutional for Congress to legislate in ways that cross-subsidize, whether you or I might like it or not, as a personal matter. And I think there are quite a few laws that have been passed under the Commerce Clause power that do effectuate some cross-subsidization, and they're not unconstitutional for that reason.
Next question.
Thank you. Yes, James Young, National Right to Work Legal Defense Foundation. So I am always entertained when I hear the free rider argument. Because, of course, General Cordray, the free rider argument is an intellectual fraud. The free riders are created by government action. I would ask the panelists, all of the panelists, to address the notion that perhaps we should consider the fact, or consider the argument, or raise the argument even, that if Congress has a problem of its own creation in the form of socializing one half of medical care in this country by Medicare, socializing another portion of it with Medicaid, and then telling insurance companies you have to take people who aren't responsible enough to buy insurance and ignore the fact that they haven't bought insurance and can't set your premiums accordingly, that perhaps Congress shouldn't be able to penalize the rest of us by portraying these people as free riders when the only thing they're riding on free is the government's effort to buy votes.
I think that's a political objection, and it's a political issue you're raising. But I also think that the free riders do impose costs on us, whether you want to acknowledge it or not. They impose costs on us right now by free riding. And they go to the emergency room, and that care is somehow paid for by someone, and ultimately it ends up affecting your and my premiums.
Because Congress says they have to be treated there.
Well,
It's not.
we could leave them in the streets, I suppose, but that's not the society we've developed.
It's not a strictly a policy argument. If the defenders of the bill, the government attorneys defending the bill, are using a free rider claim to justify the necessity of their act under the necessary and proper clause, now they have turned this into a policy argument. They've turned a policy argument into a constitutional argument by making this claim on behalf of the constitutionality of what they did. They're either doing that or they're simply engaged in surplusage, that none of the parts of their brief which discuss the free rider problem are relevant to the constitutional question to which the brief is addressed. So it's either relevant to their constitutional theory or it's not relevant to their constitutional theory, in which case the free rider, the existence of the government manufactured free rider problem is on the table for being discussed. I would prefer, and I advocate, that we don't get judges into the discussion of whether something is or is not necessary because it's a free rider problem or not, but we establish a bright line rule, or at least, there's no rule that's completely bright line, but we establish a distinction of the kind that the court established in Lopez between activity and inactivity in order to decide this matter for all cases, regardless of whether the government can manufacture a free rider problem of its own making.
Just to add, and of course the bright line test that Randy is advocating and we're advocating is the best one, but to deal with the government's argument, we in fact are making some hay, particularly in the papers we're going to file, on the fact the government is creating its own necessity. And those of you who would read the wonderful debates to which Randy referred about the First Bank of the United States, and even read McCulloch, cannot walk away but not be impressed with a notion that if you told them at the time that the government would be creating its own necessity for a variety of things, they would have been horrified, because that's the worst kind of bootstrapping. That would truly make an unnecessary and proper clause a sweeping clause. And again, don't need to elaborate on your excellent question, but the government has created this problem over the course of years, and now has gotten a deal with a coup de grace. By the way, again, half of it is rhetoric, I suppose, but it has some constitutional significance because, as Randy says, the government is making hay out of it. Think about the peculiar way the government regulates the insurance industry. It killed the insurance industry. It ain't insurance. Insurance involves individualized risk assessment, or at least risk assessment in the context of a certain pool, and premium costs reflecting the actuarial blah, blah, blah. If you tell insurance companies to insure everybody at flat rates with no concern for pre-existing conditions, it would be like asking individuals in the casualty insurance to allow somebody to insure his house after it burned down, or allow survivors of dead people to go in within 30 days and at a fixed price purchase a life insurance policy.
That would be unconstitutional.
I would say that no. If regulating insurance companies is no. I'm not saying that it's unconstitutional in some sense, aside from takings issues. Let me be bold and say, if you voluntarily chose to engage in the stream of commerce and government regulates you in a way that drives you out of business, you have a takings issue, but it ain't Commerce Clause wise problematic. But that's not what the government is doing. To remedy its own design of destroying the insurance industry in any logical sense of word insurance, it is sweeping in inactive individuals. That's why my point about the more ambitious and unattainable are its regulatory goals, the more you need general police power, because you can't get there by operating on the basis of enumerated powers. And that is fundamentally jarring.
David, given the court's amenability to the free rider argument, I wish you luck, which is why General Cordray raises it, because unfortunately it has been bought, at least in the context of forced union dues, for more than 60 years.
All right, we have time for one more question from the audience.
I'd like to go back to Morrison, because it seems to me that if a man is beating up his girlfriend, she might have to go to the emergency room, and that's going to raise the cost for the rest of us. So why isn't Morrison wrongly decided if the mandate is constitutional?
I'll just say one thing briefly. The only thing the government is trying to tell here is this. The problem of Morrison and Lopez was that those regulations were very narrow. But if you put them in the context of a broader statute, you can bring them all in. That is the basic argument they're making. Because you're right, there are same consequences from the conduct, from activities in Morrison and Lopez. At least they were activities versus inactivities. And that's a
Sounds
very
like
good-
Rach to me.
Well, first of all, I just want to say that I was a tort student in Charles's class 35 years ago. So I never thought, and when he was up there giving his talk and he said, so what? Boy, did that bring back memories. Never did in a million years when I was sitting in that torts class. I think 35 years later, we'd be sitting up here on opposing sides. Well, I probably could have predicted we'd be on opposing sides. But not that we'd be sitting up here. The Raich case. I feel a little bad about the Raich case, I have to say, as someone who believes in federalism and limited powers. But the Raich case is greatly overread by the same law professors who were very surprised when Lopez was decided. Remember, for 35 years or more, for 40, 50 years or more, the courts had failed to strike down any law because it had exceeded Congress's power under the Commerce and Necessary and Proper clauses. And so law professors really thought Congress had a plenary power, and that was it. That's how I learned constitutional law. But then that happened, and their constitutional law professors were really shocked when that happened, and they really thought, well, there were some problems with the findings there, and if all they had to do was make findings next time, and everything would be okay. And then Morrison comes along, and they had lots of findings, and they had hearings and stuff, and they thought, oh, wait a second, maybe the court's seriously about drawing a line here. And then lower courts started thinking, well, maybe the court's serious about drawing a line here, which is part of the reason we won in the Ninth Circuit in the Raich case, because the Ninth Circuit thought, well, maybe the court was serious about drawing a line. And then we get up to the Raich case, and it turns out that the court upholds the act in the Raich case. And now law professors have all just reverted back to their original position, which is that Congress has an unlimited plenary power subject to a rational basis test to do whatever it wants. I think that overreads the case.
This is a perfect example of the old adage, in the house of the hanged man, do not speak of rope.
Okay. So the Raich case was about an as-applied Commerce Clause challenge. It was not a facial challenge to the Controlled Substances Act. We conceded the basic constitutionality of the act, and we said that as applied to a person who is growing marijuana on her own behalf, Angel Raich and Diane Monson, growing marijuana themselves, Congress can't reach that far. And what the court held was that as an as-applied challenge, when it was necessary to reach this activity, it could do so. And what was the justification for that? Not Justice Scalia's concurring opinion. By the way, Justice Scalia is a big hero of progressive law professors now because he has this wonderful concurring opinion in the Raich case. But what did Justice Stevens say? Justice Scalia did not join the majority opinion in Raich. What was the reasoning of Justice Stevens? He said, well, the reason under our case law, Congress can reach intrastate activity if it's economic in nature. Is growing marijuana economic in nature? Justice Stevens answered yes. On what grounds? What was his authority? 1966 Webster's Dictionary, which defined economic activity or economic as the growing or the production or consumption of commodities. On the basis of, if we'd had known that was what we were going to lose the case on, the 1966 dictionary, we would have looked at some other recent dictionaries to see if there might be some other definitions of economic. So essentially what the majority opinion in the Raich case holds is my clients were engaged in economic activity, and therefore they can reach it. There was dicta in the case that talked about the essential to a broader regulatory scheme. That's true. And then there was Justice Scalia's concurring opinion in that, but that's not the holding of the case. So I'm just here as a poor, humble, former Cook County State's Attorney lawyer trying to read the Supreme Court opinions as best I can to figure out what the doctrine has said in the past and to see what the courts might do with it today. If there is a will, there is a way. Now here's the question. Is there a will? And here is where politics might just enter the equation. I know, you know, we all know that the court bends over backwards in order to uphold popular legislation. But will the court bend over backwards to uphold something that is really, really unpopular when there is a valid constitutional argument to be made against it? I think perhaps not.
For me, this was a real treat because in my prior life, before I became a judge, I was a constitutional law professor. So one of the things I would love for all of you to do is thank our panelists for an absolutely wonderful panel. Thank you.